Okay, we're going to get started. Thank you all for joining us this evening for the 2025 Supreme Court wrap-up, where we will discuss significant decisions coming out of this Supreme Court term and their impact on civil liberties. My name is Madeline McGonigal, and I am the Policy Associate at the ACLU of Rhode Island. I'd like to kick off this program with a quote from one of the founders of the National ACLU, Roger Baldwin, who once said, "No battle for civil liberties ever remains won." We're unfortunately seeing this sentiment ring true in the decisions being handed down by the Supreme Court and which we will discuss during this program. But it's important to note that and it's encouraging that there are organizations and people like the panelists I will present to you in a moment who are fighting every day to continuously win back those battles. There are also things that you all can do every day to stay active and involved, which we will discuss towards the end of this evening's program. With that, please allow me to introduce you to our distinguished speakers in alphabetical order. First, Stephen Brown is the longtime executive director of the ACLU of Rhode Island. Jared Goldstein has been a professor of law at Roger Williams University School of Law since 2005, where he teaches constitutional law. He previously worked in the U.S. Department of Justice and later represented detainees held at Guantanamo Bay. He has authored numerous briefs in the U.S. Supreme Court and directs the Prisoners' Rights Litigation Clinic at the Roger Williams Law School. Deborah Gonzalez is the director of the Immigration Law Clinic at Roger Williams University School of Law. She was previously in private practice, where she represented immigration clients in a wide array of cases, and she currently serves on the ACLU of Rhode Island Board of Directors. Diana Hassel has been a member of the faculty at the law school since 1995. She teaches in the areas of constitutional law, civil rights litigation, and lawyering skills. She received her law degree from Rutgers Law School and a BA from Mount Holyoke College. Carl Krueger is a 1983 graduate of Boston University School of Law and practiced exclusively in the area of U.S. immigration and nationality law for 40 years. He was employed as a staff attorney at the International Institute of Rhode Island and its successor, Dorcas International, from 1987 to 2024. He has been an active volunteer with the Rhode Island affiliate of the ACLU for the last 2 decades and currently sits on the affiliate's board of directors. Lynette Labinger is a longtime ACLU of Rhode Island cooperating attorney and a very well-known civil rights lawyer that has successfully litigated numerous civil liberties victories. And just before we start, I want to give a little bit of administrative overview. There's a Q&A button at the bottom of your screen where it looks like the one that's here on this slide. If you have a question at any point during our program, please put it in the chat and we will have a portion of the program where we will address those questions. Going forward, I will introduce each of the cases and give a little bit of the background about them. Each speaker will then discuss the implications that decision will have on the public. We'll start our program with U.S. versus Skermeti. Just a little bit about what happened in this case. In 2023, Tennessee enacted a law which banned the best practice medical care for trans youth up to 18 years of age and required trans youth who were currently at the time receiving gender-affirming care to stop receiving that care within the law's effective date. This law also established a private right of action against medical providers providing medically necessary care to trans youth. In April 2023, the National ACLU filed suit to block this ban, but in June 2025, the Supreme Court ruled by 6-3 and allowed the Tennessee law to remain in effect. Turning over to Lynette, could you tell us a little bit about how this will impact the public?
So, good evening, everyone. United States versus Skermeti was brought by several transgender youth, their parents, and medical providers. It was originally supported by the United States under the Biden administration. When the administration changed, the Trump administration was obviously no longer supporting it. The court upheld the Tennessee law, which bans gender-affirming medical care for transgender youth up to the age of 18, including both medication and surgical procedures. Now, none of the plaintiffs were challenging the surgical procedures, but they were challenging the cessation of the medical procedures, which were primarily puberty blockers to stall or halt the impact of puberty, both for children who identify as female but are biologically male and vice versa. So I want to roll back in time because back in 1974, in a case involving a challenge to a California law, it was called Geduldig versus Aiello. The California law provided, it wasn't necessarily called TDI. We have TDI locally, temporary disability insurance. So the law provided that if you had to be out of work because you had a short-term disability, there was insurance coverage, but it excluded pregnancy. And it was challenged on the basis that this is discriminatory against women, and the court, in its illustrious wisdom, said, no, that's a condition. That's not sex-based. Even though it only affects women, it doesn't affect all women. So it discriminates or distinguishes between women who are pregnant on the one hand and men and women who are not pregnant on the other. It was from a societal standpoint, viewed as a ridiculous decision. Congress stepped in a few years later, passed laws that made it clear that sex discrimination bans under employment included pregnancy and childbirth-related conditions. But Geduldig versus Aiello was never off the books. And it raised its head again in the Skermeti decision, in the majority decision, where they said this law, which bans gender-affirming care for minors, does not discriminate on the basis of transgender status. It only impacts certain medical procedures, and it distinguishes on the basis of age. And so if you are under 18 and there's a procedure that is related to gender dysphoria, those things are excluded. But if you have another reason to take puberty blockers, such as some kind of early acceleration of puberty, whether you're a boy or a girl biologically, you can get those drugs, but you can't get them for gender affirming care. And the court basically said, we don't view this as based on transgender status. We view this as based on medical and minority majority, and we apply a much more lenient standard to measure such challenges under the Equal Protection Clause. And on that basis, they upheld this law, which is similar to laws in about 20 states. That's all the bad news. The good sort of news is that by distinguishing it on that basis, they did two things. They left open the door to other challenges based on transgender status that are not and cannot be upheld because of a medical consideration or minority status. And they also recognized at some level that transgender status is a status. If you've been keeping up with the Trump administration, in January of 2025, the president issued an executive order that declared that as far as the federal government was concerned and to be enforced in every agency, there are only two sexes. They're both biological, male and female, and nothing else exists. And this decision basically does not support that position because it recognized that there are transgender youth, and left to another day decisions about whatever the standard is for determining if a law discriminates on the basis of transgender status. It also recognized and did not roll back at all from the Title VII decision, which has to do with employment, that making decisions on the basis of sexual orientation or transgender status is a category of discrimination on the basis of sex and is prohibited by Title VII. As far as how this affects Rhode Island, right now, not particularly, because we don't have a legislature that's trying to ban or put burdens on transgender status. So that's the somewhat good news.
Thank you for that explanation, Lynette. We're really grateful. Our next case that we'll cover tonight is called Free Speech Coalition versus Paxton. In this case, the US Supreme Court ruled that Texas can require websites to check users' ages using ID or other verification methods if more than 1/3 of the content on the site is sexual material considered harmful to minors. The court's majority said this requirement doesn't violate free speech rights because it mainly aims to protect kids and doesn't completely block adults from accessing legal content. It just adds an additional step. To talk a little bit about this case, we're going to turn now to Steve Brown.
Thank you very much, Madeline. Hello, everybody. Like the case you just heard, the Scrimeti case, this one and the one I'm going to be talking about in a few more minutes, it shows the Supreme Court really taking a deep dive right into the culture wars, and not for the better. This decision has, we think, very serious implications for both free speech and privacy rights. Well, first and foremost, in terms of its impact, there are a number of other states that have passed similar laws to Texas. And since the Supreme Court has upheld Texas's law, we're going to see these types of age verification statutes taking effect in many other states across the country. One of the most disturbing things about the decision is that it really is the first time the court has allowed infringement on the free speech rights of adults in order to protect minors. The dissenting opinion by Justice Kagan noted that the court over the past 20 or so years had struck down 4 other laws that had also attempted to regulate internet access for minors by regulating adults as well. And the court said that in all those cases, that was unconstitutional. In this case, however, the majority said that the impact on adults constituted only an incidental burden, and therefore it was okay. The incidental burden is a very serious burden. It requires age verification. So what that means is adults have to provide government ID or some other formal identification in order to get on these websites. And I think it's very easy to see the chilling impact of having that sort of requirement would have on individuals wishing to gain access to what is constitutionally allowable material for adults. It's also very problematic to think about what's going to be done with that information once it's collected. Will it be sold? We all have to be concerned about hacks. But the court really just shrugged all those things off, and the decision ends up really impacting the whole notion of online anonymity, which has been so important to the growth of the internet. The majority opinion, which happened to be written by Justice Thomas of all the justices, compared the requirement that adults have to provide this age verification in order to gain access to First Amendment material to having to show your ID in order to buy liquor, which is absolutely ridiculous. In terms of the further impact, I think one of the big questions is what will happen when we learn that this really doesn't work, that youth will find all sorts of ways to get around the age verification requirement. And to the extent that the Supreme Court has said we can burden adult speech in order to protect minors, what are the next steps that might be taken by legislatures that the court might uphold in order to protect minors from this type of material or any other material that's deemed harmful to minors? I think the other thing that remains unclear is how will this decision affect social media generally? Social media was exempt under the Texas law, but we know that there are a number of states that have passed or are considering passing laws to regulate social media in the same way, to require parental consent for minors in order to gain access to social media and so forth. So one of the things that I know a lot of people who are concerned about this decision are going to be looking for is, will the Supreme Court end up expanding it? Will legislatures try to take it even further? And the impact ultimately could be significant, not just on adults, but also on minors as well, who are looking for legitimate information on the web, sexual health information, and so forth. So there are a lot of unanswered questions, but I think the one thing we can say is that unfortunately, this decision really is a big step backwards in terms of protection of First Amendment rights.
Thank you for that explanation, Steve. And as you hinted, don't go too far because you're on deck for the next one as well. The next case we're going to talk about is Mahmoud v. Taylor, which in October 2022, a Maryland school district approved LGBTQ plus inclusive books related to sexual orientation and gender identity for its English language arts curriculum. Initially, the school board of that district allowed parents to receive notice and opt their children out of lessons involving these books, in line with the district's guidelines for religious accommodations. In March 2023, the school board reversed this policy and eliminated the notice and opt-out options without explanation. Several parents of different religious backgrounds sued the school board, arguing that the denial of the notice and opt-out options violated their religious freedom and parental rights. In a 6-3 decision, the court held that the board's policy of not permitting notice and opt-out poses a, quote, very real threat of undermining, end quote, the religious beliefs and practices parents wish to instill. Back to you, Steve, about this one as well.
Yeah, well, this is certainly getting right into the culture wars, and again, not in a good way at all. This decision is troubling on so many levels, and the dissent pointed out the potential chaos that this might cause for public schools across the country, that now will have to consider just about any religious objection that parents have to anything that's being taught in the schools or being shown in the schools, or maybe being in the schoolroom library. I think a couple of quotes from the majority opinion by Justice Alito just help explain just how broad and troubling this decision is. As you heard, this case is grounded on the Free Exercise Clause of the First Amendment. And Justice Alito begins his opinion by saying this, in terms of why this is so important to allow parents to be able to religiously object to books that are being taught in the classroom or in the classroom. He said, for many people of faith across the country, there are few religious acts more important than the religious education of their children. Due to financial and other constraints, however, many parents have no choice but to send their children to a public school. As a result, the right of parents to direct the religious upbringing of their children would be an empty promise if it did not follow those children into the public school classroom. So essentially, the justice is sort of turning the First Amendment on its head and is saying that public institutions have to completely bow down to the interests and religious beliefs of parents, regardless of what those religious views might be, and turning public schools essentially into accommodational institutions to promote religion. Very, very troubling. The other thing I want to mention is one of the books, these are elementary school books, one of the books was called Uncle Bobby's Wedding, and Justice Alito took great umbrage about it because it showed a child who was learning about a same-sex marriage in their family. And I have to, again, just very quickly take a quote from Justice Alito's opinion. The girl asks, why is Uncle Bobby getting married? And Justice Alito says, the question is used as a direct message to young readers. Quote, Bobby and Jamie like each other, said Mommy. When grown-up people love each other that much, sometimes they get married. And Justice Alito interprets that to say, the book therefore presents a specific if subtle message about marriage. It asserts that two people can get married regardless of whether they are the same or opposite sex, so long as they love each other. Well, yeah, that's something they have a right to do. It is the law. They do have a right to get married if they love each other. And the fact that Justice Alito quotes the book for that proposition, as if to say it's wrong, gives you an idea of what this decision is all about. So I think I know a lot of educators are very concerned because of the breadth of the decision and the vagueness of the decision. You know, parents who want to object about their kids learning about evolution. I mean, you can just go on down the list. You can imagine all the difficulties it will cause schools. And I think one of the biggest concerns is that it may encourage schools to stay away from various important topics to talk about, for fear that a parent might say that whatever they talked about interfered with their religious beliefs. So this is going to play out now over the years. I'm sure over the next few years, we'll see how far the courts are willing to go to essentially allow parents to dictate what gets taught in the public schools. Again, very disturbing, but time will tell just how much of a significant impact it will have on the public school system.
Thank you for that insight, Steve, on the future of curriculums. We're going to shift gears a little bit towards a case called Trump v. CASA. On his first day in office for a second term, President Trump issued an executive order that declared certain individuals born in the U.S. would not be granted U.S. citizenship at birth if their mothers were either in the country illegally or temporarily, and if their fathers were not U.S. citizens or lawful permanent residents. In an effort to block this attack on birthright citizenship, several lower courts issued broad injunctions stopping the enforcement of this order. Again, in a 6-3 decision, the Supreme Court ruled that federal district courts generally cannot issue universal injunctions that block these federal policies for everyone, stating that these sweeping injunctions go beyond the power Congress granted to federal courts. Turning this over to Jared to talk a little bit about the impacts of this case.
Hi, everyone. It's good to see your names, at least on the screen. I hope you're doing well. So, yeah, as Madeline said, Trump versus CASA arises out of President Trump's executive order on birthright citizenship, but the court's decision doesn't actually address that order. That is, it doesn't address whether birthright citizenship is constitutionally protected or not. Instead, what it addresses is the power of lower courts to act when they decide that the president or an executive agency is acting unlawfully. It's actually pretty difficult to predict what impact the decision will have on Rhode Island residents or on anyone else. So we'll have to wait and see. But just to give you a little, more flavor of the case, in the birthright citizenship executive order, what President Trump did was to declare that people who are born in the U.S. Are not citizens if their parents are not are without legal status, and that EO conflicts with decades of precedent and practice, and would clearly seem to conflict with the 14th Amendment, which says that anyone born in the United States is a U.S. citizen. The executive order was challenged by a bunch of people, individuals who are affected by the order, as well as organizations, and by states. And 3 district courts said that the order was unconstitutional and issued an injunction ordering the president not to enforce it. But instead of just saying that the order could not be enforced against the specific people and organizations and states who challenged the order, the district court said that the executive order, that is the birthright citizen order, could not be enforced against anyone, whether they were parties to the suit or not. And this is a so-called nationwide injunction or a universal injunction, which prohibits the application of a challenge policy or law to anyone, not just the parties in the court. And so in this case, the Supreme Court said that courts can't ordinarily issue injunctions like that. They can only issue injunctions to protect the specific parties who brought the suit. And that decision made the dissenting justices, Justices Sotomayor, Kagan, and Jackson, essentially made their heads explode, because what they said was that, courts should be able to tell the executive branch to stop breaking the law anywhere, everywhere, against anyone. And by limiting the power of the lower courts to issue these nationwide or universal injunctions, it creates a zone where the president must follow the law, that is, where a court has issued an injunction against him, and another zone where the president is allowed to violate the law, that is, where the president hasn't been enjoined. So we may have a patchwork of jurisdictions where the president is allowed to act unconstitutionally in some places and prohibited from doing the same thing elsewhere where there's an injunction in place. Now, the decision might be a big deal. A lot of people think that it was a big deal. Certainly, the dissenting justices thought it was a very big deal. That is, when the president takes action that only some judges see as unconstitutional or illegal, the president can keep doing it in places where it's not enjoined. On the other hand, it might not be a big deal. The Supreme Court does allow these universal injunctions under some circumstances, for instance, where it's necessary to protect the specific parties. And the court says that maybe states need birthright citizenship to be or the birthright citizenship order to be enjoined everywhere to protect them from the disruption if they have to deal with the fact that some people born in some parts of the country will be deemed to not be citizens, even though they would be deemed citizens in their states. States have to administer all sorts of benefit programs that are limited to citizens, and they would have a very difficult time trying to figure out how to administer these programs if people born in some states are citizens and people who are born under the same circumstances in their states are not, or to protect their citizens if people in Rhode Island go to Texas, if Texas has a different rule about birthright citizenship, how can we, our state, protect their citizens if they travel to another state? The court did seem to suggest on some circumstances, nationwide injunction might be required. And in fact, that's what happened just yesterday. The Ninth Circuit said a universal injunction is necessary to protect the states against this unconstitutional birthright citizen order. Again, it may be that the decision will end up not being that big of a deal. It's just hard to say. One other thing to note, about these nationwide injunctions is that they cut both ways. When Democratic presidents have taken action, they were subject to universal injunctions. For instance, when President Obama adopted the DAPA program, that gave status and protected parents of dreamers from deportation, a nationwide injunction stopped it. And when it adopted a Title IX rule on bathroom access for transgender students, it was subject to a nationwide injunction preventing it. And the Biden administration student loan program was enjoined in a nationwide injunction. And in all of these cases, conservative litigants went to jurisdictions where they knew they could get conservative judges to stop these programs and allowed judge shopping. And so these same nationwide injunctions cuts against Democratic presidents when they do things that conservative judges don't like. And of course, none of us should be surprised. I think that the Supreme Court majority didn't protect the Obama or the Biden administration from these nationwide injunctions, but now it steps in to protect the Trump administration from these same kind of injunctions. Of course, that doesn't mean that as a general matter, these nationwide injunctions are a good idea or a good policy, but they are a tool to stop unconstitutional action. But just as I say, they can be used against programs that you might like. The importance of the decision, as I say, isn't clear. Where it's likely to have the biggest impact is in preliminary injunctions. That is, what should happen when the president does something new or big, and it's going to take a while for the Supreme Court to sort it out, to figure out whether the program is lawful. And this can take weeks or months or years before a final ruling by the Supreme Court. So before this CASA decision, individual courts, as lower courts, could put a stop to these programs in the interim. Now, in most cases, they probably can't. And so it's likely to take the Supreme Court to stop unlawful or unconstitutional action in the weeks, months, and years before it issues a final decision. And so what that means is, the decision empowers the Supreme Court at the expense of lower courts. And at the same time, it empowers the president to be bold, to take actions that he thinks the Supreme Court will let him get away with, and not just ones he thinks that the lower courts would let him get away with. So it changes the president's calculus about what he thinks he can get away with. So now he mostly needs to look at the Supreme Court and count the votes there instead of just trying to figure out whether a lower court might stop it. And that may end up being a very significant change.
Thank you, Jared, for that insight into this procedural case. I do want to remind everyone that if you've had any questions throughout this program thus far, the Q&A box is available for you, and we will get to those questions later in the program. Turning now to the next case, which is called Medina versus Planned Parenthood South Atlantic. In 1967, the free choice of provider provision was added to the Medicaid statute, which allowed Medicaid beneficiaries to obtain medical assistance from any qualified provider. Flash forward a few years to 2018, when the governor of South Carolina issued an executive order that directed the Department of Health and Human Services to eliminate abortion clinics from the Medicaid program. As a result, DHHS informed Planned Parenthood that it was no longer qualified to provide services to Medicaid beneficiaries and terminated its enrollment agreements immediately. Again, in a 6-3 decision, the Supreme Court held that Medicaid beneficiaries do not have an individual court-enforceable right to choose any qualified provider, such as Planned Parenthood, even though Medicaid law requires states to allow it. Diana, could you walk us a little bit through this case?
Sure. So this case, first of all, good evening, everyone. This case is really about, it's about Medicaid, but it's also about Section 1983, which is the statute passed in 1871, which allows individuals to sue actors, either state actors, who have violated constitutional rights or rights provided by the laws of the United States. So what this case decided is that the statute, the Medicaid statute, which required that, which mandated that individuals can obtain services from any qualified provider, did not provide a right that individuals could enforce through Section 1983. So the laws that could be protected by Section 1983 did not include this Medicaid law. And the court sort of came to this sort of tortured analysis and distinguished laws passed by Congress under its spending power, which of course Medicaid is a program where the federal government sends money to the states contribute some money, and together the program is administered. It is largely administered by the states, but there are many conditions imposed by the federal government for the receipt of this money. One of these conditions was that the states can't prevent an individual from obtaining services from any qualified provider. So what happens when the state doesn't do that? Precedent had previously established that, well, then an individual can sue under Section 1983 and saying, hey, my rights under this federal law, the Medicaid law, are being violated. State, you have to stop it, get injunctive relief, perhaps get damages. But the court here said, oh, there's a difference between laws that are passed under the spending clause, which is really a relationship just between the state and the federal government, and the individuals that it benefits are not really involved. And so in those situations, it's very unlikely that there is an individual, a right for an individual to try to vindicate the promises under that statute. And it went through a kind of, again, tortured analysis to try to distinguish prior cases which had allowed such suits under 1983, previous Medicaid cases under National Labor Relations Act benefits, public housing cases, and said, oh, well, in those cases, there was much more explicit it was very explicit on the part of Congress that they were trying to create an individual right as opposed to just provide a benefit. And of course, this is, so we're going to look at the very words and say, did you say the word right? Or did you just say the word the state must? Really, what it reflects is a real hostility to private enforcement of these federal laws, so that if a private person, and in this case, a woman who was receiving non-abortion care from Planned Parenthood, other kinds of health services, can no longer go to Planned Parenthood for her services that are covered by Medicaid. She will have to find some other provider but she brought the suit because of her particular circumstances. Planned Parenthood had the best expertise in dealing with her situation. So it reflects a real hostility to vindication of federal rights. It also reflects a real hostility to Planned Parenthood. I think this is also a part of the culture wars. These other cases that were allowed, individuals were allowed to bring suits, were perhaps in less controversial areas, like the rights of people in nursing homes to get certain kinds of information and to have certain kinds of protections. Those were allowed, but this was not. And of course, there was a very strenuous dissent by Justice Jackson, basically saying, what are you doing? The statute, Section 1983, says rights protected under the laws of the United States. It doesn't make a distinction based on what power Congress used to pass that law, whether it was the commerce power or the spending power or some other power. You're just creating this whole distinction. And that the Medicaid Act put this provision in just to prevent this kind of state governments being able to say, oh, we want all the Medicaid money to go to our friends, these particular medical providers, and these other medical providers can't be part of it. Well, this is exactly what's allowed to happen now. And of course, many states will follow suit and will take Planned Parenthood. It will say Planned Parenthood is not a qualified provider and cannot be part of Medicaid reimbursement. The only remedy now is for the federal government itself to step in and say, oh, states, you can't do this. And the mechanism for them to do that is to withdraw the funds from the state, which of course would be a horrible outcome for all the people who are getting these benefits. So in essence, there is no check on the states for this behavior. Perhaps even more troubling, there's a Justice Thomas concurrence where he suggests the whole scope of rights that can be protected, both constitutional and under the laws of the United States, under Section 1983 ought to be reconsidered. And he wants to narrow the conception of what is a right. So the government taking away a benefit is not a right. And he wants to distinguish and eliminate a lot of things, particularly under procedural due process protections that have been able to be vindicated under Section 1983. Now, he was speaking alone. He didn't have anyone else join his opinion, but that may be the way they hope to go in the future. Others have also suggested this limiting private, individuals being able to try to use federal law to protect individual rights is also very relevant for the Voting Rights Act. The issue is now being discussed and is litigated in certain circuits about whether a private individual can bring a suit to enforce the requirements of the Voting Rights Act. And some have argued that no, they can't. Again, only the federal government can require the states to do what is mandated under the Voting Rights Act. Again, another attempted rollback of the way these laws are actually enforced. The federal government doesn't largely enforce them, either because they don't have the resources or they're not hostile to what the state has done. And so without these individual lawsuits, federal rights will not be protected. I don't have any, and there's something good here. I really don't. The only thing I have is Justice Jackson wrote a very stirring opinion about what Section 1983 was about and how broadly it was meant to be interpreted and how inconsistent this decision is with that history.
Thank you so much, Diana, for that insight. We're switching gears now a little bit, and we're going to talk a bit more about the immigration-focused cases. I'm going to give an overview of 3 separate cases and at one time, and then I'm going to turn it over to Carl and Deborah to give us a little bit more insight into each of those. The first case we're going to talk about is Nome versus National TPS Alliance. Temporary protected status is a program established by Congress to protect individuals who cannot safely return to their home country due to war, natural disaster, or other emergency. Hundreds of thousands of individuals are considered TPS holders and are permitted to live and work in the United States for statutorily defined periods. At the beginning of the Trump administration, Department of Homeland Security Kristi Noem began to take steps to terminate temporary protected status for a group of over 300,000 Venezuelans, stripping them of their rights and undermining the program. In an unsigned order, the Supreme Court paused a lower court ruling that had blocked Secretary Noem from terminating the protections. Moving to the next immigration case is Department of Homeland Security versus DVD. This case challenged the Department of Homeland Security's policy of deporting non-citizens to countries the government never raised as possible countries of removal during their immigration proceedings, without any notice or opportunity to contest removal due to fear of persecution, torture, and even death in the third-party country. However, in an unsigned order, the justices allowed Department of Homeland Security to implement this policy. The third case that I'll turn over to Carl and Deborah shortly is Trump versus JGG. On March 14th, 2025, the Trump administration invoked the Alien Enemies Act, which is a wartime authority passed originally in 1798, which allows the president to apprehend and remove citizens of a foreign country that is engaged in a, quote, declared war or, quote, invasion against the U.S. In his invocation, Trump asserted that a criminal organization from Venezuela had invaded the U.S. Following suit from the national ACLU, a judge approved a temporary restraining order barring the deportation of 5 Venezuelan men who were held under this act. In an unsigned decision, the court granted the Trump administration's request to pause the lower court order that blocked these deportations under the Alien Enemies Act. However, the court unanimously rejected the government's argument that the courts are powerless to review the president's decision and held that due process requires giving people a fair chance to challenge their detention and deportation in court. Now turning the program over to Carl and Deborah.
All right. Thank you, Madeline, and thank everyone for participating in this evening. I'm going to talk about the first of these two cases, the TPS case and then the DVD case. The TPS case is peculiar because there is a very explicit statutory provision that the government must follow if it's going to terminate the grant of TPS. This is the result of the Reagan administrations and prior administrations machinations back in the day when they would arbitrarily grant protection to groups of people and not grant protection to other groups of people, to the point where after a decade of State Department officials going in front of Congress and lying about the conditions in El Salvador, Congress finally got fed up with it and enacted a statute that is supposed to be the sole provision for granting a group of people permission to be in the United States because of the danger of returning to their home country. And there is an explicit provision for terminating the TPS protection, requiring the government to go on the record and explain why things have changed, what has changed, making the danger no longer evident, and providing a timetable for doing this. And the Trump administration, instead of following those rules, declared that the president has the right to vacate the determinations that were made by the previous administration as far as the danger to people returning home. And this affects literally hundreds of thousands of people. Right now in this TPS lawsuit, not only the Venezuelans who have the TPS, but also Haitians who have TPS have been included in this lawsuit. And we're talking about, at this point, about 1.1 million people, about 600,000 Venezuelans and about 500,000 Haitians who are affected by this. And again, both of these communities are represented in Rhode Island. Scores, if not hundreds of people are going to be affected by this. Additionally, there are another 15 countries that have TPS or have had TPS recently. So we're talking a very, very large number of people across the country and a very substantial number of people in Rhode Island. The these cases are progressing rapidly. There's going to be a hearing coming up within the next couple of weeks on the merits of this case. So there might be a decision that would be favorable if that does happen. If it doesn't, if the government is in fact allowed to revoke the TPS status of 1.1 million people, they're going to go out of status. And what that means is that they're either going to be put into removal proceedings, into a system that is already tremendously clogged up with people waiting 5 to 10 years for hearings, or they're going to be forced to apply for asylum. And that system is already very much backed up. There aren't enough asylum adjudicators to handle the cases that they have now. So to dump 1.1 million people into these queues is, again, going to just create tremendous chaos. It remains to be seen what's going to happen with this, obviously. On the other case that I'm going to discuss, the DVD case, this is totally uncharted waters. This is a scenario that never would have occurred more than 6 months ago because of the way that deportation proceedings were done. In the initial stages of a deportation proceeding, generally, one of the first things an immigration judge is going to do is determine to which country an individual is going to be deported if, in fact, that is the resolution of the deportation case. And this is important because U.S. immigration law and international law, and this is one of the few times where U.S. immigration law actually tracks recognized international law, there's a principle called non-refoulement. And what this means is that an individual cannot be sent by a government to another country if that individual is going to face some kind of persecution or danger. And this is explicit. And the way this is written into the Immigration and Nationality Act, it kind of trumps everything in terms of sending someone outside the United States. The government can't send somebody to a country where his life is going to be in danger. So, in the old days, prior to 6 months ago, the government would determine which country the individual is going to be deported to, and the individual at that immigration hearing would have the opportunity, if he was fearful of being sent to that country, to apply for protection from being sent there. And he'd either win or lose the case. If he won the case, then he couldn't be sent back to that country. If, on the other hand, he lost the case, then the government had the responsibility for trying to deport him to that country. And in some circumstances, they could. The country wouldn't recognize the individual. We might not have diplomatic relations with that country. So there were circumstances where individuals couldn't actually be sent to the country designated by the immigration court. And in those circumstances, that was kind of the end of it. The government generally did not seek another country to which to deport somebody. That has all changed now. Like the flip of a switch, the government has decided, and not to be too crass about this is a transactional thing. The government of the United States is paying countries, giving countries other things to get them to take people that aren't their citizens, but who the government of the United States now wants to remove from the United States. So this is why we see the torture center in El Salvador being used. And in this particular situation, there are some African countries that are willing to take people from the United States. The problem is that these folks are not being afforded any kind of protection, any kind of opportunity to show that they are fearful of persecution in these other countries, because they've already had their hearings. And there isn't any provision under existing law to reopen their proceedings and give them another hearing in front of an immigration judge, the only individual with the responsibility for making this determination as to the well-foundedness of the individual's fear of being persecuted. There isn't any mechanism for doing this. And the government is simply ignoring the statute that says that the government can't return somebody to a place where he's fearful of returning. That clearly implies that the individual has the opportunity, is going to have the opportunity to present his reasons for being fearful and to have an adjudicator make those decisions. The government now is relying on representations by these countries that are willing to take our deportees, that they won't be persecuted there. And the government of the United States is asserting that that's enough of a protection to insulate the individual from a non-refoulement claim. So again, uncharted waters. We're going to see where this goes. The hearing on the merits is coming up in a couple of weeks. There's in the TPS case, there's a motion for partial summary judgment that's going to be heard apparently at the beginning of August. But in both of these, I mean, the impact is just it's unfathomable. There are so many people in deportation proceedings, and if the government isn't giving individuals the opportunity to exercise their right to show that they're fearful of being sent to one of these countries, then the government is just completely disregarding the fundamental due process rights that these statutes establish. So, not much good news on that front. We'd like to think that there is a chance that on the merits of these cases that the plaintiffs will prevail. We'll see. Debbie? It's all yours.
All right. Thank you, Carl. So I am talking about Trump v. JGG. And so this is the case wherein the president invoked the Aliens Enemy Act of 1978, which is a very old wartime statute that allows it to be invoked if for some reason the United States is at war with another country, or if we've been invaded by individuals that belong to another country where the country is actually involved. And so here plaintiffs were a group of men who were believed to have invaded the United States with a gang called Tren de Araguas from Venezuela. And the government started to detain people that they believed, based on tattoos that they had on their bodies, to assume that they were members of this gang, Tren de Araguas, which the president had proclaimed had invaded the United States. The plaintiffs in this case filed a motion with the court to prevent the government from deporting them. And I'm sure you all heard in the news that, the flight took off before the hearing, or the hearing was going on while the flight was in air, and the court in an oral decision told the government to return them, but the government didn't do it because the decision was oral, and that they didn't believe that the decision was a valid decision simply because it was oral. That is not what the court decided here. In fact, they didn't even touch upon that. And what's super interesting about this case is that this case was brought up on appeal by the government, because the government had filed in the district court. This case comes out of the district court of DC, and the district court denied the government's motion to vacate its own temporary restraining order from deporting these folks outside of the United States. So the government files an appeal to the Supreme Court. And its decision, the majority basically says, so the issue here, I guess let me back up for a minute. The issue here is whether or not the members of this class of people that had been detained were in fact members of Tren de Araguas, and whether or not these group of folks had invaded the United States. So that's the reason why the case came before the district court in the district of DC. And that's the reason why the court issued the temporary restraining order from deporting them, so that the court could figure out whether or not these folks had been properly included in this gang Tren de Araguas, one, and whether or not this gang Tren de Araguas had in fact invaded the United States. Government files a motion to vacate. The district court denies the motion. The government files an appeal to the United States Supreme Court. asking them to reverse the temporary restraining order, allowing them to deport people to El Salvador, as they did in this case, without giving them any notice. And the court here basically says, well, we're not going to decide whether or not the folks that you've detained are part of the group Tren de Araguas, and we're not going to decide whether or not this is in fact an invasion, because we believe, the majority, that what the plaintiffs did is that they filed the wrong lawsuit. Instead of filing a class action lawsuit claiming that they're not members of Tren de Araguas and claiming that they didn't invade the United States, what they should have done is that they should have filed a habeas. So we're finding that this claim is no good, and what they should have done is that they should have filed a habeas and then sent the case back saying that the petition itself that's before the district court is no longer any good. Why is this problem? Well, I'll tell you what they did do, which was good. They did say, however, that the Aliens Enemies Act is only reviewable in certain circumstances as it relates to issues of the Constitution or an interpretation question, which the court here doesn't reach because they think this should have been a habeas case and not a class action case, which violates the Constitution in and of itself. So it's super interesting that the court decides what the plaintiffs should or shouldn't have done. But what they do say is that, notwithstanding what this case may be about, and that they need to have filed a habeas petition, that what the government needs to have done, and they say that the government also concedes this, is that each of the members in this group of people that had been deported to El Salvador should have been given notice and an opportunity for them to respond in a reasonable manner to a habeas petition. In other words, that they should have been afforded notice, and that the foreign nationals should have been given a reasonable amount of time to allow them to seek a habeas relief in the proper venue. The court here says that this case is in the wrong venue because, again, these petitioners filed the wrong petition. They should have filed a habeas petition, and the habeas petition could have only been filed in the place where they were being held, which at the time was in Texas, just before the plane took off. And therefore, the court essentially says that the petition in and of itself is no good. What's interesting, and probably not the best about this case, is that this is a per curiam decision, which means that the decision is a summary decision by a majority of the justices. And per curiam cases are problematic because, generally speaking, these cases do not require the parties, either the plaintiffs or the defendants, to file any briefs with the government to make their arguments, nor does it require any oral argument. So the court in this case did two things. One, it said, well, your class action lawsuit on the constitutional issue and the interpretation issue on the Aliens Enemies Act is not proper, and we're just going to find it that you should have done a habeas. And also now we're going to find that it's not in the proper jurisdiction. And what the dissent says is, well, you did not allow the lower court to decide that. You did not allow the lower court to figure out whether or not the petition in and of itself was incorrect. In other words, that the district court in DC needed to have said to the plaintiffs, you filed the wrong petition. You needed to have filed a habeas, and then the district court needed to have allowed the parties an opportunity to brief that so that the district court could then make its interpretations and then have the case sent over to the Supreme Court for them to make this decision. And instead, in a summary decision, just decided, well, we're going to say that you should have done a habeas, and also that habeas is the only relief that a person could seek, which the dissent also says that's crazy. We've never ever said that relief for a person is only in a habeas petition. What the court, on the positive, did they allow the plaintiffs in this case to now seek a habeas? Maybe, but now they're all in El Salvador, so I don't know what they're going to be able to do. Essentially, what they did was to throw out the decision that was in the district court by saying that they filed the wrong petition. And when the case goes back to the district court can't now hear it because now the Supreme Court's already said this is the wrong petition. They don't have relief under a class action. They needed to have filed a habeas petition for them to be able to challenge the Alien Enemies Act. The other thing that the majority said in this per curiam decision, which I thought was a positive, is that in a habeas petition, it will allow each petitioner to claim that that they were improperly included in this group of people, in this group of gang members, and then to say that they themselves did not invade the United States because they were improperly included in this group of gang members. Two small positives as it relates to people in Rhode Island. I think that the people in Rhode Island who are going to be considered part of Tren de Araguas and maybe subject to the Alien Enemies Act will now have an opportunity to file a habeas petition wherein the government must give them a reasonable amount of time for them to seek habeas on their behalf. So that's a positive. You know, Justice Jackson really, I think, reamed the majority in this dangerous issuing per curiam decisions without full hearings, without cases being briefed or oral argument when the implications of these decisions are incredibly serious. And so, you know, unfortunately, I think we've heard tonight that every single one of these cases, there was definitely a division split. And I'm sure our listeners today can envision who the dissenters were, right? Sotomayor, Kagan, and Jackson for the most part. In my case, Justice Barrett also dissented in part, but then, you know, concurred in also part, I think, although we don't know who wrote the majority because it was a per curiam decision. So that's it. That's all I have for this case.
Thank you both so much for that insight. We know that this has been a bit of a heavy program with all of these decisions we've been discussing, but I'm going to turn it over to Steve to talk about why we should not despair just yet.
Thank you, Madeline. I mean, we probably should despair a little bit. This is very depressing to hear all these cases all at the same time. But I do think it's important that we end on a note and recognize that this is not the end by any means. And I just want to give a few examples. Here in Rhode Island, our affiliate has joined with other groups in 5 lawsuits so far this year against the Trump administration. We've worked in collaboration with the national ACLU on a couple of cases. We've worked with other New England affiliates in one particular case dealing with immigration and the summary revocation of student visa status for students across New England. We filed suits along with local groups, including the Lawyers Committee of Rhode Island, on cases, including one that was just decided today. A temporary restraining order was issued today in a case dealing with unlawful conditions that were imposed on nonprofit groups like the Rhode Island Coalition Against Domestic Violence, the House of Hope, the Coalition to End Homelessness. In order to get grant money from HUD and Health and Human Services, they had to agree to a whole bunch of ridiculous conditions, such as not promoting gender ideology, whatever that is, not promoting elective abortions, and on and on and on. And, you know, of these 5 lawsuits, in 4 of them, we have achieved preliminary victories. And then the 5th one hasn't been decided yet. So there's still, you know, notwithstanding the Supreme Court's efforts to take away rights in various categories, there's still lots of hope and there's still lots of opportunity to challenge what's going on. So I don't want people to leave thinking that, you know, this really is hopeless. The Supreme Court just keeps on issuing these terrible decisions. They do, but the lower courts still have a really significant role to play in protecting individual rights. And we're seeing that happen right here in Rhode Island. The second thing is that there are ways to deal with some of these decisions, at least, through legislation. And here in Rhode Island, our affiliate, along with many other groups, have been working on bills to try to address some of these issues. So in the immigration area, for example, the General Assembly this year passed two pro-immigrant bills. One that bars landlords from asking tenants or prospective tenants about their immigration status, one that prohibits hospitals from asking patients or prospective patients about their immigration status. There are a number of other bills that were introduced this year that didn't pass, but that I expect to get introduced next year that we will be working on, and we encourage any of you who are interested to help in contacting your legislators to support those bills. Another really big bill that passed this year, it sort of is a counter somewhat to the decision I talked about, the Mahmoud decision dealing with, the restricting LGBTQ books in the schools if parents objected to be able to opt themselves out of dealing with it. Rhode Island passed a strong Freedom to Read Act. It doesn't address the books in the curriculum, but it does protect school libraries as well as public libraries from efforts to censor books, to take books off the shelves by people in the community. It sets up very strong safeguards to prevent that from happening. So Rhode Island is doing something to prevent something from happening that we see happening everywhere else. So I just want to mention, these things to make you aware. It's not the end of the world. We still need to fight. As you heard at the beginning from Madeline, Roger Baldwin's message that no civil liberties battle ever stays won. But it also means that no civil liberties battle ever always stays lost either. So we hope you'll keep that in mind as we end this program.
And we do apologize that time has run out, so we can't get to questions, but we do implore you to submit the questions that you have asked to the email that's on the screen, info@riaclu.org. We also have our social media links here if you would like to follow us, as well as a link to donate or a QR code to support us in this effort. Thank you all for tuning in this evening, and I want to say thank you to our panelists for sharing their expertise with us this evening. We really appreciate all the insight that you've given us this evening. Thank you again.